Good afternoon, everyone. Welcome back on the conference, the third day in the afternoon session. Quick note before we start, if you have missed any sessions, you can watch them back on YouTube. We are currently uploading the sessions from the last couple of days, and we will continue doing that. So I expect that already during the weekend, actually, all the sessions will be up so that you can watch anything back that you have missed. Also, before I start with the panel session, we would like to highlight some of the upcoming events from Asia Center. So first of all, on the 4th of November, we have a webinar which is organized with the Taipei Economic and Cultural Office. This is on countering the coronavirus-related infodemic. So also very much related, obviously, to the COVID, the COVID pandemic and disinformation, fake news, etc. So that is something interesting to sign up for. Then we have on the 18th of November, we have the ASEAN-Japan relations, the impact of COVID-19 pandemic. Also in a webinar roundtable organized with the Japan Foundation. And then last but not least, already on our agenda for next year, our annual conference, also on COVID-19 and in Asia, communication, nationalism and technology, which is co-convened with the Graduate School of MEDA. So that's regarding our upcoming events. And then I would like to continue with our next panel session. And this one we are moderating ourselves, although it has been supported by Ravi, but Master Ravi is currently in the court. He had to attend urgent death penalty cases before the Singapore court. So therefore he's unable to attend, unfortunately. But we have a very interesting panel, which is very much about regulation and mediation. So on our panel, we have we can go to the next slide. Yeah, we have the following people. So first of all, we have Maude Morrison, who is from the Centre of Humanitarian Dialogue. She is a social media and conflict mediation advisor. She calls in from Paris, but her work is very much related to Asia, and she has been based in Myanmar for a couple of years. So obviously, she has a lot of interesting insights from that perspective. And she will be talking about the link between social media conflict and mediation processes. And I'm sure she will address also some of the experiences in Myanmar. Then we have Kirril Shields, who is a research fellow and project coordinator at the Asia Pacific Center for the Responsibility to Protect. And he's also a lecturer at the University of Queensland. He will talk about the different legislation in Asia related to hate speech. So he will lay out the landscape there. And the paper that this is based on also addresses hate speech in the countries Philippines, Myanmar, India, Australia, and Indonesia. So we might also hear some examples from that.
Sorry, Belen, can you hear me? Sorry.
Yes, yeah.
I've hijacked that, so I'm going to be talking a little off topic. Sorry.
Yeah. No worries.
Sorry, I will talk on it briefly, but I've hijacked the rest of it. Sorry.
Okay, no worries at all. No worries at all. Good. Then we have Jeremy from the Gadjah Mada University in Indonesia, who will talk about the Blasphemy emergency, Indonesia biggest crisis. That's the title of the paper that his presentation is based on. So that is very much related to legislation being used to suppress minorities, basically. And then last but not least, we have Anugrah Wishnumurti, and also from the Gadjah Mada University, who also takes a more legal approach related to hate speech. And the paper that his presentation is based on is about the consequences of hate speech regulation. Can we rely on a legal approach? So these are the speakers and the presentations that we will listen to, and then I would like to start with Kirril. The floor is yours. And in the meantime, we will put up the slide.
Great, thank you very much for the introduction, and thank you very much to the Asia Centre for holding this conference. And I apologise because I've had to work, so I've been zooming in and zooming out over the course of the last 3 days, and I've caught a lot of it at all sorts of weird hours in the morning, and because I'm over here in Brisbane. But it's been really wonderful, and I think I'm going to double up on some of the content in so much legislation, but I'm just going to talk more on a project that myself and 4 others have been conducting over the course of the past year. And you can hear me okay, I'm assuming?
Yes, yeah, very much.
Good, okay. So yeah, the other thing is I'm going to read, otherwise I'll go off on tangents. So apologise if I'm looking down. I'll just sort of keep to the script, otherwise I'll go on for half an hour. So the title of the talk is Facebook and Hate Speech in the Asia Pacific region, Regulation and Regulatory Literacy, which somewhat differs from what I had originally proposed. But the paper is one that I'm presenting on behalf of a team of that we've been working together over the past year, and that team consists of myself, Professor Catherine Gelber at the University of Queensland, Dr. Aim Sinpeng and Dr. Fiona Martin, who I don't know, some of you may be aware of or have worked with before. And about a year ago, or sorry, if you could just, sorry, just one back, yeah, sorry, yeah, thank you. So about a year ago, myself and the 4 others were funded by Facebook to explore hate speech on that platform and sort of to come up with suggestions when thinking about regulation in regards to Facebook's hate speech policies. So the overall project's aims, and this is ongoing, it won't last too much longer, but the aims have been to hopefully share with Facebook our opinions of what they're doing well and also what they're not doing so well. And when thinking about regulation and also think about through mediation and in regards to hate speech. And over the course of this year, we've explored many Facebook pages, too many Facebook pages, I have to say, from a variety of Asia Pacific nations. With a particular focus, our case study was on LGBTQ+ communities and hate speech, whether they've been the targets of hate speech or not. Of course, they've been targets of hate speech, but really the question is, how well have Facebook moderated these particular Facebook sites, and whether have they have been able to take down the hate speech, or they've left it up there, and for what reasons. So the 5 countries we used as our case studies are India, Australia, the Philippines, Indonesia, and Myanmar. So here in the presentation, what I'd like to do today is to sort of talk a little bit about how we as a group work together with Facebook on regulation and mediation in regards to hate speech, and to give you some sort of insight into our broader findings. And if you are interested in the country-specific findings, I'm more than happy to forward them on, but what I'm going to do now, given time restraints, I'm just going to give a broader overview. So our methodology was, very quickly, first, we needed a definition of hate speech that allowed us to work with Facebook's 3-tiered community standards. If you know much about Facebook, they have community standards that are ongoing and evolving, and they used to be 2, but now there are 3. So we needed a particular type of definition. Second, we also determined that we needed to explore legislation in Southeast Asia or South Asia, which we've done, and this is what originally the proposal was on, but it's sort of moved on from that. And in doing so, sort of questioning who has responsibility when it comes to taking down hate speech. Is it the government, is it legislation, or is it the private sector and Facebook? Third, we chose case studies, and in this case, we looked at LGBTQ+ community pages across those 5 countries that I mentioned. And then, well, on that briefly, that also meant that ourselves, and we had research assistants across those particular countries looking at thousands and thousands of hate speech, Facebook posts, which was very interesting. In Australia, what I found out was actually not a great deal of hate speech around these sort of communities on Facebook. And that's not because there isn't hate speech, it's because Facebook do quite a good job in Australia. But I actually got quite depressed because I realized my fellow country people are quite dumb. I got after thousands and thousands of reading this quotes, I got quite depressed about the state of Australian politics. But so with this in mind, the 4th thing we did was determine just how prolific hate speech was or not. And then in doing so, we sought to interview Facebook employees from each region. They were the page admins and the Facebook market specialists. They're sort of the Facebook titles, and interview them and ask what their roles are. And we've since written a report and made a number of recommendations, and these sort of recommendations I'll share with you. And then, so what I'll do is I'll share some of these findings and then talk broadly in the final moments on working with Facebook in regards to regulation and regulatory literacy. So the next slide, please. Thank you. So when devising our definition of hate speech, we were really lucky to have with us on the team Professor Catherine Gelber, who you may have heard of, who's at the sort of forefront of devising and coming up with hate speech definitions. And she's worked on the Rabat Plan of Action, for example. And this is what we came up with in this sort of instance. We said that we understand hate speech not as a speech that merely offends someone or hurts their feelings, as we well know, but as a speech that can harm immediately and over time, and that therefore, and to that extent, this warrants a policy response from Facebook. So we're aiming at specifically at Facebook. We said that hate speech discriminates against people on ground of their perceived membership of a group, even if they're not members of the group, their perceived membership, and that marginalizes in the context in which the speech is uttered. And so very broadly, as I say here, we said that hate speech had to be a public act. It's aimed, that the person it's aimed at is a member of a marginalized group. So that in itself is kind of interesting, but also problematic. Some would say that the speaker or poster needs to have a base of authority, whether it's formal authority or informal authority. It may be that they're in governance, but it also could just be some weirdo who has a huge following of people on Facebook. And there's an assumed act of subordination that ranks targets as inferiors and therefore legitimates discriminatory behaviour against these targets and deprives them of powers. And with this definition in mind, we then adopted the following code. If you could go to the next screen, please, to reflect this definition in relation to Facebook's community standards. So you can see here, we brought our definition is at the top, and we broke it down in discrimination, inferiorization, and deprivation. And that equates to Facebook community standard equivalents, tier 1 and 3, tier 2 and 3, and tier 3. And if you're familiar with this, it'd make more sense. And then we also, in amongst all this, we have a number of examples. Just I'll leave them up there, but I won't talk on them exactly. So with that in mind, next slide, if we could, please. Great. When it came to legislation, and most of us already know something about this because we've talked long and hard about legislation already at this particular conference. Well, the Asia Pacific region lags in many attempts in attempting to curb online hateful content that may incite and lead to incitement and violence. And what we found was that governments across the region may have proposed hate speech legislation by some civic and penal codes, as the Asia Centre will know with their recent report. But legislation directly dealing with hate speech still sort of sits to the sideline. And an example of that in the Philippines is the House Bill number 3672. That's been there as a bill for many years, but sort of sits there under today's government, is not going anywhere. But what does exist in the region, and this is something we've also discussed in this conference, is legislation that kind of speaks indirectly to hate speech. So we have, for example, religious freedom acts, cyber laws, electronic media acts. So laws that vaguely address the topic, but never extend so far as to curb hateful content, or could be used to do so, but often is not. And as a result, we found that even though NGOs and civil society organisations across the region are trying to educate civil and government organisations about hate speech, there seems to be a general reluctance to write this into legislation. And some backlash is, of course, that worry about limiting freedom of speech. There's always like, no, we're going to limit people's freedom of speech, and don't really understand the nuance between the two. But for the most, we think the hesitancy signals sort of a government's reluctance to realise that this is an ever-going problem that needs policy and legislation to curb it. And most governments seem to see that this problem needs to be countered by corporations and businesses, and the onus in this case is on Facebook to do something about it. And one of the last interesting things about legislation that I made note of here, that the semantics of legislation in the region and the way bills and acts are worded. So aside from Australia, where the region, where Australia uses the words incite and incitement, in legislation around the region, there seems to be a sort of a softer language, such as to offend, to insult, and so on, suggesting that in fact hate speech as the sort of equivalent to teasing or belittling or annoying rather than actually being a crime, an act that could lead to sort of a serious act of criminality. So in sum, what role government in helping to curb hate speech on Facebook? We found little to none. And in fact, what we also found was that in fact, some of the legislation actually helps to spread and legitimize hate speech in a particular region. Good, thank you. So with that in mind, we had a definition outlined, and we realized that legislation is relatively ineffectual. We took to our case studies, and these are our methods in more detail. If you go to the next slide, please. So we looked at the 3 most popular LGBT+ community pages in Australia, Indonesia, India, Myanmar, and the Philippines. And the methodology consisted of sort of a content analysis, a number of different ways. And the posts numbered tens of thousands, so it was really quite comprehensive. It was all done by person, one after the time. We had no sort of software to help us, so that was really quite onerous. And as I said, the interviews. And if you want to know more about the specifics on that, I'm more than happy to give you the report once it's finalized in the next couple of weeks. But as a result, if we can go to the next slide, please. Here are our key findings. One, we found that hate speech experiences are really context dependent and require local knowledge to identify. So this is something that Facebook has not addressed as yet. They seem to think that any sort of training can come out of San Diego or other sort of places like Silicon Valley, and they don't take into consideration language within a certain region, nor do they take into consideration sort of local knowledge and those particular needed context. Secondly, that the definition of hate speech used by Facebook does not cover all targets' experiences, so it's kind of inadequate. And even though Facebook are constantly updating this, we found that their definition compared to ours didn't really help. In fact, it helped. All it did was cause confusion amongst some of the Facebook staff that were doing the moderating. We also found the third point, that there is a little explicit hate speech legislation in the Asia Pacific region, and so I've already mentioned on this. We move down, and this is where it gets kind of interesting, that many moderators do not engage directly with hate speakers in believing that it actually escalates their risk online and offline. So there's actually a tendency amongst those who moderate to sort of shy away from doing any moderation in fear of repercussion. And that speaks a couple of things. Firstly, it speaks to what sort of posting are they talking about that they fear for their lives. Secondly, that there's a kind of naivety when it comes to those who are employed by Facebook, thinking that they can be traced or they're going to be tracked down on the streets. So there was this kind of discord amongst moderators and the job they're doing in compared to what, it's the reality of the situation. We also found that in Myanmar and the Philippines and Indonesia, most page admins don't understand Facebook community standards. They haven't been trained in this at all. They don't know it. There's certainly no language, there's certainly no translation into specific languages in some of these cases. And sometimes we also found that their training when it came to Facebook and community standards was from a third-party organization and not from Facebook itself. They'd gone out on their own accord to find training to help them explain what to do when it came to moderation, and Facebook had played no role in this. So it led to that next key finding, which is that the most common form of hate speech management by page admins is just to leave it alone. And of course, we have artificial intelligence doing some of the work, but if the artificial intelligence doesn't pick up on nuance and the rest of it, as has already been discussed in this conference, that the page admins in this case don't pick it up. And it means, that we also found that if they do pick it up and it is hate speech, often Facebook at a higher level keep that up on the Facebook, and so it confuses the moderators. So yes, they flagged it, they found it, they want it taken down, but Facebook has decided to keep it up on their pages, which has confused those page admins. And so, as I said in the last point, much of the material reported to Facebook is therefore not removed, and all page admins as a result report feeling disempowerment and feel disengaged from the actual process. So in the last slide, just very quickly, well, what this has led to, so what we mean then when I'm talking about regulatory literacy is that we also, as part of our recommendation, suggested that there needs to be some regulatory literacy rest with the user. And this speaks to social media and the way people who use social media don't really understand how it works. Sorry, I'm a little off track again. When it comes to Facebook, if I was to condense the findings that I just highlighted above to one key factor that needs fixing, is that Facebook staff, those who moderate hate speech, and this includes those and page administrators and also the market specialists, they lack the necessary literacy to actually be able to decipher hate speech. And in part, this is because Facebook often seem content to rest with AI and artificial intelligence in both text and in an image form, and hope that technology removes hate speech postings. When, and as I've said before, this in fact does not occur. And what happens is that Facebook then rely on their own moderators, and we get this inadequacy as we saw before. And hand in hand, obligatory training doesn't happen. And this means that moderators may not feel compelled to take on any training, and page administrators, who are the key regulatory actors, do not know what they're doing. They seem guided by their own rules and definitions, and many are not sure and are not sure on how to interpret Facebook's rules and Facebook's policies. And lastly, we found that even when some content is flagged correctly by those page administrators, as I said before, as hate speech, it is sometimes not taken down, causing more confusion. And we also found that there were inconsistency with the appeal process across countries. A user could appeal when moderators made a wrong decision, and the outcome of this is then never explained to those administrators. So, and on top of all that, there's a lack of transparency. So in sum, our findings show us that legislation does little to curb hate speech on Facebook. And while Facebook's moving in kind of a right direction in some countries, such as when we saw QAnon being taken down just recently, in country-specific localities, there's a real lack of knowledge about what hate speech is and what hate speech isn't. And so we're finding that hate speech is on the rise instead of actually lessening. And I'll leave it at that. Thank you.
Thank you, Kirril. Very interesting. And I have some thoughts and questions coming up, but we can leave that for the Q&A session so that we will discuss it then. Then I would go on to our second speaker, which is Maude Morrison from the Centre of Humanitarian Dialogue. Excuse me.
Thanks, Belen.
Yeah, the floor is yours. I'm handing it over.
Thank you so much. And thank you for having me. Also to the Asia Centre for organising this really, really interesting conference. And thanks, Kirril, for those remarks, which were interesting. Also have some questions. So let me just say a few words about the Centre of Humanitarian Dialogue for anyone that doesn't know who we are. So Centre for Humanitarian Dialogue, or HD, is the largest private conflict mediation organisation. So we're active in about 20 countries around the world. We work on more than 30 different peace processes, and essentially what we do is mediate between conflict parties or work with conflict parties in various regions. And in Asia, we have quite large country programs in Myanmar and in the Philippines, but we've also worked in some other settings in Southeast Asia. I'm quite new to HD, so that's as much as I'm going to be able to tell you. My role with them is to support them on their thinking around social media, and particularly on two things. So on the one hand, how is social media changing the way that conflicts are happening? And then secondly, what does that mean for the way that conflicts should be mediated in the digital spaces as well as offline? So all of that to say that when I was asked to speak on this panel, when we talk about the issue of hate speech, we're really thinking about it from the angle of conflict and conflict mediation. So we're interested in hate speech because we see it in many cases as part of a driver of conflict. And I think that's been talked about quite a lot during the conference already. You mentioned, Belen, that I used to be based in Myanmar and worked quite a lot on looking specifically at hate speech relating to the intercommunal conflict there. So that's kind of the interest that we have in this topic. And what I want to talk about today is kind of our approach, and it might be slightly different from some of the other speakers, our approach that looks at how can we maybe mediate online spaces from a conflict mediation perspective, rather than just a content moderation perspective, which has been kind of the common angle to talk about when it comes to the topic of hate speech. A lot of discussions so far around hate speech, and a lot of the work and focus has been, rightly so, on how to respond to hate speech once it happens. So how to take it down, how to report it, how to correct misinformation that goes beyond hate speech. But these kind of reactive, what we call downstream responses to hate speech. And even some of the more proactive responses, things like promoting media literacy or promoting people, sort of supporting people to better identify and report hate speech. Even those responses tend to rely quite a lot on citizens themselves, on internet users themselves, being able to identify, report, or sort of ignore hate speech when it happens. And few responses, I think, so far have really tried to deal with the propagation of hate speech at its source. So really stopping it before it happens, or dealing directly with the actors who are putting out some of this hate speech, that are not just your average internet user who starts sharing posts, but really the source of the problem. And so without doing that, and these responses that are more about content moderation, about taking down hate speech once it's happened, they are really important. And I don't want to be seen to be saying that they're not. They're really, really necessary. But I think they can only get us so far if we don't also go beyond some of these responses. One, because if you don't deal with the problem at source, it's going to be very difficult to minimize to any meaningful degree the levels of hate speech. It's like putting out fires. You can put out a fire here, but it can spark another fire over there. And so content moderation, which the platforms have been very focused on, is a bit like that. And they can get better, and they are getting better at putting out the fires, but there's still something burning underneath that we think is important to talk about. And that links to my second point, the sort of part of the problem with some of these approaches that look at hate speech after it's happened. They're very focused on removing content, so taking down any instances of hate speech. And that's like the gold standard of a lot of these approaches, like, well, let's get rid of it once it happens. And yes, in many cases, we should get rid of it. But we also have to be a little bit careful that we're not what we call burying the signal. So hiding the symptoms of actually a much broader disease. So when we see hate speech online, particularly when it's in a conflict setting, it's usually the signal of a much broader problem and much deeper divisions between different sides. And by focusing only on quelling it, so on burying it, removing it, we sometimes miss the deeper signals behind this hate speech, which is actually what we should be addressing. And if we're coming from a conflict mediation perspective, then that's what we're interested in, the kind of behind the scenes. What is it that's causing particular types of hate speech to be propagated? And how can we address the sort of broader societal disease, to keep using the medical analogy. So that's kind of what I've been thinking about for a while. And now that I've joined HD, who are very much a mediation organization, and they work to, in many cases, negotiate or support agreements that prevent conflicts from escalating. So that's very much like dealing with the conflict at its source, or dealing with deeper roots of a problem rather than just stopping violence. Traditionally, HD have been focused on the offline space. We're not generally a digital organization, but we're starting to realize that mediation when it comes to conflict cannot only focus on offline spaces, it has to also deal with online spaces, and things like hate speech are a really good example of how conflicts are playing out in online as much as they are offline. So we need to deal with that reality. And so what we're asking ourselves now, and we don't have a paper or sort of, this is all quite new thinking, so I'm really interested in any feedback or reactions or further conversations. But what we're interested in is, okay, well, how could we, as a mediation organization, start to think about dealing with hate speech upstream? How could we apply some of the principles of conflict mediation to the challenge of hate speech or generally conflict in online spaces? Concretely, what we are looking at is what would it mean? How could it work to actually engage in a dialogue with conflict parties about how they're behaving online, including about, but not limited to, the propagation of hate speech? So could we actually address some of this before it's happening, and eventually come to some kind of agreements, what we're calling social media codes of conduct, that would actually mediate behavior in online space in a particular case, particularly in a case where there's conflict parties, or where there's a peace process ongoing and the conflict parties have an interest in mitigating some of the online conflicts. I'm just checking you can still hear me, because my internet is telling me it's unstable. Still fine?
Yes, yeah, we can still hear you. The sound is
Okay, good. Okay, good. So we're looking at, well, what would these social media codes of conduct, what would they look like? Something that might encourage conflict parties to exercise constraint, which would in turn then limit the amount of particularly conflict-related hate speech that we might see online. These kinds of codes of conduct, which we're starting to think about and start to develop a little bit of like practice behind. So we're starting to think, well, what could this look like? How would it work? How would you even come to negotiate this kind of agreement? They wouldn't be focused primarily on hate speech only. They would probably cover content. So that would include hate speech, but it might also include other things like misinformation, for example. And they would also probably have to cover behavior, because content is only one part of the problem in online spaces. So the way that, for example, people are using information operations or coordinated and authentic behavior, probably we want to address these issues as well, but I'll obviously think it's relevant for the discussion on hate speech. A code of conduct on social media would probably also cover both issues relating to the conflict itself. So hate speech, because it's relevant because it's a driver of conflict, and if we're trying to mediate a peace process, we would want to include those online drivers of conflict. Would also probably incorporate discussions about a particular peace process. So you can imagine a case where there's a mediation process ongoing between two sides of a conflict, and a code of conduct might want to lay out how parties should or shouldn't talk about that negotiation process, which is not hate speech, but I think it's relevant to this idea of mediation in the online space. We're still discussing and thinking and talking to a lot of people about, well, what would the content of some kind of online code of conduct or some kind of mediation process about online spaces, what would it include? And I think at a very basic level, it would include both what we call restrictive clauses. So restrictive clauses is essentially something that says we will not do this. So that could be, we will not propagate this kind of hate speech that's related to the conflict, or we will not conduct doxing of key activists in this context, for example. So those are restrictive clauses. And then there would also probably have to be active clauses. So things that actually actively encourage, we will do X, Y, or Z. And that might be encouraging proactive content about a particular peace process. But in the case of hate speech, it might be actively encouraging specific responses to hate speech. So if we see conflict-related hate speech on our pages or in our networks, we will respond in this way. So we can imagine that you might be able to include some kind of process for responding, for countering hate speech, for example, or for actively reporting it. So these two sides to the coin. One is, well, what will we not do, and the other side is, what will we do? Because we know that these are never, any kind of agreement is never going to be able to completely mediate the online space, and that would be really naive if we thought that that would be the case. But so that's why there has to be some sort of proactive response to say, well, we acknowledge that this will still happen, but it won't happen from us. But when it does happen, what do we do about it? And I think that the idea of these kinds of very specific agreements or dialogue processes on online spaces, the idea is that we need to go beyond just the community standards that Kirril talked about, which are already useful. But if you're looking at a very specific context, as you mentioned, often the community standards don't go far enough when it comes to hate speech. So the idea would be that a code of conduct could really lay out, well, what are the specific types of hate speech that we would want to regulate in this context. So you can imagine looking at a case like Myanmar, for example, and looking at the specific languages or the specific topics that conflict parties might agree not to engage in. And the big question is obviously might. There are huge challenges to this, and it's still very much kind of an idea. And then there are three sort of challenges that are top of my mind. So the first one is definitions, and Kirril, you talked about, well, the first step in any conversation is defining hate speech. So, and the term hate speech is still very broad. And I think for any kind of mediation of online space to work, it needs to be very specific about what specifically is the behavior and the content that you're trying to regulate in this case. And we'd have to start any process with a really in-depth analysis of, well, what are the issues in this case? For example, hate speech, what are some of the elements of hate speech that we're interested in? Are things like subcultures of language, so coded language that refers to a specific group that's relevant in a conflict. That kind of level of detail would have to be really explicit in order to make this feasible. The second big challenge is obviously incentives. What are the incentives to bring people to the table to talk about behavior in online spaces? Obviously, that's a challenge for mediation processes in general. And I think it's an additional challenge here because the lines of responsibility are very blurred when it comes to online space. So it's not as clear cut as, say, the use of weapons or the engagement in offline war. That said, there are things that the mediation field have learned about when is the right moment to engage people in a dialogue, when is the right moment to start a process. So I think we can learn some things from that too. And then the final challenge is monitoring. So there's no point ever having any kind of agreement unless you also have a monitoring system that's robust and that can respond to or identify and support response to any violations. So it's no point people sitting in a room and saying we will no longer propagate hate speech online if there's no mechanism to identify whether or not they do actually stick to that agreement. And we know from hate speech work in general that monitoring hate speech is difficult. It can be time consuming, and that will apply in this case too. So we would need to think really carefully about how we would monitor this, both in terms of specific violations of any agreement and also then like in general, how is this affecting the online space and how is it shifting anything? Is it making a difference? And again, goes back to this line of responsibility being blurred. Like it's very unlikely that it would be the direct conflict parties or the sort of leaders in any negotiation process that would be themselves posting hate speech or other things. It's often several steps removed. And so how do we identify that and how do we know about it? So I think I will stop there, and just to summarize very briefly, Number one, I think that responses to hate speech should not just happen after the fact, but that we need to really think about dealing with them at source, as well as dealing with them after the fact. I think that the mediation field has a role to play. The conflict mediation has a role to play that's underexplored. It's not something that they've traditionally thought that much about. But there is a role to play in addressing hate speech and digital conflict more broadly. And thirdly, I think that dialogue around hate speech and online behavior directly with conflict parties in a conflict setting is an area where more work needs to be done and where there's potentially a lot of room to explore. So I will stop there and I look forward to the discussion later.
Great, thank you, Maude. Very interesting and a very unique view, obviously, towards hate speech prevention. How do we cope with it, but that without burying the signal, and how you said it nicely. Yeah, very good, very interesting. And I can imagine some questions will come up because it's a topic that we haven't really discussed over the last couple of days. Obviously, we discussed like prevention, but not really in the sort of the mediation kind of way, and how can we cope with it without taking it down? Yeah, and how can we have that sort of also this online conversation in that sense? Good. Then we would go on to Jeremy, who will talk about legislation in a different way. So maybe not so much in a positive way, but how can it also be used to suppress certain minorities in Indonesia in this case. So I'm handing over to Jeremy.
All right, thank you, Belen, and thank you, Asia Center, for holding this amazing 3-day conference about hate speech in Asia. That really intrigued me to be joining this amazing conference. So allow me to introduce myself. My name is Jeremy Guntur. I'm a third-year law student at Gadjah Mada University. And this is my research paper about Blasphemy Emergency, Indonesia Biggest Crisis, for Asia Center 5th International Conference, Hate Speech in Asia, Challenges and Solutions. So for your info, for everyone here, talking about blasphemy in Indonesia is a very really sensitive topic because many people use blasphemy laws to oppress the minority and as a tool to oppress the people they don't like. So let's move on the first slide. Okay. All right, so the first thing first, let's talk about the definition of blasphemy itself. The first one is, according to Black's Law Dictionary, blasphemy is a hate crime because it is stated that blasphemy is the offense intended to wound the feelings of mankind or to exert contempt and hatred against the church by law established. But according to scholars Leonard William Levy, it is stated that blasphemy is the act of insulting or showing contempt to a deity or a sacred objects or towards something considered sacred or inviolable. So we can conclude that it is a crime against God. But according to General Comment number 34 on Article 19, Freedom of Opinion and Expression of ICCPR, it is stated that prohibitions of display of lack of respect for a religion or other belief system, including blasphemy laws, are incompatible with the covenant. Thus, for instance, it would be impermissible for any such law to discriminate in favor of or against one or certain religions or belief systems, or their adherents over another, or religious believers over non-believers, nor will it be permissible for such prohibitions to be used to prevent or punish criticism or religious leaders or commentary on religious doctrine and tenets of faith. So according to the ICCPR itself, it is stated that blasphemy laws is incompatible with the covenant itself. So why certain states, including Indonesia itself, still applying blasphemy law in their criminal code? So let's start to look deeper from the constitution in Indonesia. So according to Article 156A of Indonesian Criminal Code, it is stated that by a maximum imprisonment of 5 years shall be punished any person who deliberately in public gives expression to feelings or commit an act of A, which principally have the character of being at enmity with abusing or staining a religion adhered to in Indonesia, and B, with the intention to prevent a person to adhere to any religion based on the belief of the Almighty God. So in Indonesia itself, this law of a blasphemy is used to arrest many people. So from the data, 2020, there's more than 100 people has been arrested using this blasphemy law. So later on, we will discuss about the two of the most biggest case of blasphemy law in Indonesia. So let's move to the next one. All right, the first case is about Meiliana Case. So for introduction, Meiliana is a woman who lives in Tanjung Balai. It is located in North Sumatra, and she lives near a mosque. And one day when she was having her time outside her house, she asked it politely toward the mosque manager to lower down their azan volume because it is way too loud for her. So, but then the mosque manager and the people inside it think that Meiliana has conducted blasphemy toward Islam religion and then bring this case to the police. So from the noise complaint, this case was brought to the police. And after that, many riots and demonstrations are inevitable. They burn down Meiliana's house, they burn down the pagoda, which is used by Meiliana's family to conduct a prayer and etc. So the noise complaint that came from Meiliana ended with up from 80 months jail. So the judges concluded that whereas the defendant Meiliana has been proven legally and convincingly guilty of committing a criminal act on purpose, publicly committing defamation of a religion there in Indonesia, as in the prosecutor's indictment, thus, the defendant Meiliana is given a punishment of imprisonment for 1 year and 6 months. So this is the first case and the most biggest case about blasphemy law. So many questions came from people. Does this is a pure blasphemy case, or is this a politic case, or is this an oppressor to the minority? Since Meiliana is a Hindu, which is a minority in Indonesia, and the worst part is the mobs and the people that burned down the pagoda and the Meiliana's house, the case was never brought to the court until this day. So it's a very interesting case. So the second one is we talk about Ahok Case. So a brief introduction about this case. Ahok is a governor of Indonesia at that time that will be competing again in the next gubernatorial election. So one day, Ahok was doing a campaign in Pramuka Island at Kepulauan Seribu when he recites one of the most famous Al-Quran verse, which is Al-Maidah 51. It is stated that who have believed, do not take the Jews and the Christians as your friends, because they are in fact friends of one another, and whoever is an ally to them among you, then indeed he is one of them. So when Ahok recited that verse in Al-Quran, he deliberately used this verse to make sure to aware people who use the Al-Maidah 51 to turn Muslim against Christian and Jews, because Ahok thinks it will bring conflict to one another. But unfortunately, one of the visitor of the campaign back then record a video when Ahok said that and published it on a Facebook. So many arguments and hates was sent toward Ahok and his family and stated that he should be brought to the court and ended up in jail. So the people that posted the video then report this case toward the police and stated that Ahok was conducting blasphemy toward Islam by disgracing the holy book of Quran. So from that case, this is now the birth of 212 movement, which was the biggest demonstration in Indonesia, and that is conducted by all Muslim all over Indonesia. So for your info, the 212 movement is a demonstration that is conducted every 2 December. So that is why it is called as 2 December. So it is always conducted in 2 December. So is this a pure blasphemy, or is this just a politics because of the gubernatorial election? Because considering Ahok was in a campaign in the gubernatorial election in the upcoming months, and Ahok was a minority in this case. So let's see what the judge stated. It is considering that from the facts above, the defendant's statement at the Pramuka Island had abused and insulted the Holy Quran that constitutes as the holy book of Islam. According to judge's opinion, the defendant's speech is in a sense contain blasphemy and hate towards Islam as one of the religious embraced in Indonesia. So after that, Ahok is sentenced with 2 years of imprisonment. So to conclude this presentation, the biggest crisis in Indonesia is still lies on the blasphemy laws itself, which can be used as a tool to oppress a group of people that they don't like, or maybe minority, or people having different interests or political beliefs. So the second point is many critics and recommendation has been made toward the government of Indonesia to reform or change the blasphemy law so it cannot be used anymore as a tool for certain group. But unfortunately, until now, it is not yet reformed or changed. So that is all from me. Thank you for listening. I hope we can discuss further about the blasphemy law in Indonesia in the discussion session. Thank you.
Thank you, Jeremy, for this good overview and for providing us also with 2 example cases. Very interesting. Good, and then we would go already to the last speaker, which is Anugrah, who will have a similar topic on the legal topic on hate speech also in Indonesia. So I'm handing it over to you.
Okay, thank you. First of all, am I audible? Is it clear, my point?
Yes.
Okay,
Yep.
Thank you so much. So first of all, thank you so much for Asia Center as well for the really great conference. I've been following several panels since day one, and I've been getting a lot of great insights, so thank you so much. And for part of the conference, for my part of the conference, I'll be discussing about the consequences of hate speech law. But a bit of a disclaimer, I'll be discussing this from an Indonesian perspective and using Indonesia as well as an example. So perhaps we can go to the next slide. Thank you. So first of all, a bit of a groundwork for our hate speech law. Essentially, it follows the concept of limitation to speech. When we take a look at the Universal Declaration of Human Rights as a milestone in the protection of free speech, the UDHR itself is actually lacking in terms of telling us whether there is actual limitation to speech. And progressively speaking, now we have the ICCPR, specifically in Article 19, paragraph 3, which it subjects speech to limitation. And as you can see on the screen, there's the Article 19.3, in which the exercise of the rights provided for in paragraph 2, referring to free speech, of this article carries with it special duties and responsibilities. And it is subject to certain restrictions, which are point A and point B. Point A, for the respect of the rights or reputation of others, talking about the dignity of the people, and also for the protection of national security or public order or public health or morals. So essentially, the concept of limitation to speech here is not really uncommon. It is actually a concept that is internationally acknowledged. But there's still a debate out there whether or not we should really limit speech or we should really have hate speech regulation in the first place. If you take a look at Western democracies such as the US and compare it with the members of the European Union, you can see there are 2 different approaches to hate speech in terms of making regulation. In the US, if you take a look at the First Amendment, it essentially blocks all significant effort to create hate speech law in the country. The US Supreme Court resists any kind of regulations that discriminate among viewpoints, including prohibitions of offensive words or symbols, which essentially means hate speech. So when we're taking a look at the US, hate speech itself is actually protected by the First Amendment. So here, even in the current condition, the current situation with the increase of hate speech, there's still a debate, there's still the different dynamics between Western democracies, Asia, Africa, and other regions in the world. Now, moving to the next slide here. So perhaps for the time efficiency, I'm not going to talk too much about defining hate speech itself, but here I have took one definition from the UN Strategy and Plan of Action on Hate Speech. But again, I'm not going to talk too much about it. I'm pretty sure other speakers and previous panels have discussed a lot of defining hate speech. But taking a look at an example in Indonesia, we don't really have any rigid or general definition of hate speech. This is actually a common occurrence in countries in Asia. Like I think I've heard in the previous panels that other countries in South Asia, in Southeast Asia also share similarities in which hate speech are essentially loosely defined in their regulation, in the law. The same thing goes with Indonesia. In Indonesia, we don't really have any general definition of hate speech. Instead, we do have categories of speech that can be considered as hate speech. And even so, within those categories, the definitions are still loosely defined. There are no clear boundaries. There are no clear differentiation between which one is hate speech and which one is not. And talking furthermore about hate speech law, a question might arise from this kind of approach. That is the question of why hate speech law in the first place. And based on my research, there are two possible points that kind of push states to implement legal approach. The first one is the deterrence function of the law itself, and also the expressive dimension of the law. Hans Kelsen once said that the law, when he observed the law, it was used as a way to induce people in doing certain behavior, whether it is negative or positive. And that's exactly what deterrence function is here for. So the deterrence function, quite self-explanatory actually, it deters people from doing certain things by threatening with sanctions. So people will think twice when they want to do something. People will think twice when they want to say something or do something because they're afraid that it will subject them to the hate speech law, essentially. They'll face sanctions. They're afraid of that. And that's exactly the deterrence function of the law. Now, on the other side, we also have expressive dimension. Now, expressive dimension is actually quite different with deterrence function or even with the common perception of the law, because when we're talking about the law, we tend to believe and we tend to think that it's all about giving sanctions, it's all about deterring people from doing something. But expressive dimension is actually quite unique because their focus is to send a message, not just to the violators of the law, but also to the general public. The expressive dimension essentially works as a method to show the commitment of the people, the government and the people, that they believe, in this context, hate speech is beyond the line of who they actually are. Essentially, expressive dimension try to show that the people, for example, in Indonesia, see hate speech as not something that they believe to be who they are. It's like, oh, hate speech, that's totally not our thing. Let's just stay away from it. So in a nutshell, that's expressive dimension. Okay, so in this slide, we also talks about the possibilities of hate speech law as a weapon to silence, like what my colleague Jeremy also mentioned earlier, that the blasphemy law is being used to silence those who are perhaps from the other religion in the country. And there's also an opinion that limitation of speech inherently could undermine free speech. And unfortunately, I kind of agree with that statement, because when it comes to the critics of hate speech law itself, a lot of people, they tend to use the term chilling effect. So essentially, chilling effect refers to individuals that might be discouraged from doing something, from doing discussions or debates, because they're afraid that what they say or what they do will be considered or be seen as hate speech, and then they'll face sanctions, even though perhaps their intention is not to do hate speech or not to incite hatred. Perhaps their intention was just to criticize or just to show their opinion. But in the same time, other people might perceive it differently. And that's the chilling effect. And can go back to the previous slides, sorry. Okay, and also, even when there is hate speech, in the society, when people see clearly, oh, this is hate speech, it's still a bit of problematic when we see it from a legal perspective, because then there is indirect implication that the existence of a legal approach or existence of a legal rules regarding hate speech can instead create martyrs. Now, this is actually based from a research from Amnesty International that says people can just claim that they have been unjustly silenced by the state. When they criticize the government, when they actually do hate speech and then it is being silenced, they just say, oh, I've been unjustly silenced by the state. And it can actually give more exposure to the hate speech to the society. Because, for example, in Indonesia, when there's a hate speech case, the television will go wild. There will be a lot of news about it, social media will go wild, and in the end, it gives more exposure to that hate speech. Okay, so perhaps next slide. Now, going to be talking about Indonesian example, and this is the last slide. So in Indonesia, again, like what I mentioned earlier, there's no clear or rigid definition of hate speech. Instead, we have categorization of speech that can be considered as hate speech. And what is really problematic about the law here in Indonesia is the fact that the Indonesian Criminal Court, are in Indonesia, we refer it as KUHP, is actually based from a law from the 1915, the law that was created by the Dutch to rule over Dutch East Indies. So it was actually a law that many people argue, a law that was created to silence any criticism towards the colonial power. And we still use that same law until now. Even we extend that law by implementing it in our law on electronic information and transaction, law number 11, 2008, in which it extends the reach of the law enforcement, not just offline hate speech, but also online hate speech. But the implementation was not without any, was without any changes to the actual law that it was based from, the Indonesian Criminal Code. So it's still the same Dutch law that we still use. And this law was adopted in 2008. And if you take a look at the chart from SafeNet yearly report of 2018, you can see in 2015, starting from 2015, there was a significant increase. I'm really sorry, a significant increase in the case of hate speech law and being charged with the law on electronic information and transaction. So if you can take a look in 2015, there was an increase because the police actually strengthened the the implementation of the law itself by actually telling all branches of the police to really focus on processing this law on electronic information and transaction. And in 2016, there was an amendment to the law, but there was no changes at all in regards of the hate speech part. And in 2015 and 2016, there were a lot of controversies regarding the law. And because of that, the law actually gained some exposure to the people, and people actually realized that, oh, there is this law that I can use to just silence anyone that I don't like or anyone that is opposing me. And also in the same time, there were like a lot of political issues at the time. So a lot of people, they tend to use the information and technology, electronic information and transaction law as a weapon at the time. And looking back again, when I mentioned about the categorization of hate speech in Indonesia, there were several categories such as blasphemy, like what Jeremy stated earlier, and then also slander, like contempt, and also wrongful accusation. And again, all of those laws were based from a really old law from the Dutch. And still, currently there is no plan to change that, unfortunately. And also, if we talk about the implication of the law on electronic information and transaction, there is actually a really direct result from that. And in 2014, that is the end of Susilo Bambang Yudhoyono's presidency, the same presidency that adopted this law. Indonesia's democratic index status was changed into partially free because apparently there are a lot of threats from the law that makes people afraid to actually speak and to actually involve in any kind of discussion or debate. So in the end, the legal approach, I believe that the legal approach is totally not something that should be implemented solely on itself, but instead it should be as a set of approaches. And in the law on electronic information and transaction, it's actually stated that the approaches that the government use, there are 3 approaches to combat online hate speech, not just legal approach. The first one is technological approach, which focuses on cooperation with social media companies, stakeholders, essentially. And then the second one is legal approach. And last but not least is the social, culture, and ethical approach. But unfortunately, this third approach was not being implemented correctly until now. There's no program from the government at all to fulfill the last approach. Instead, the government still focuses on the legal approach. And that is problematic because then again, when there is a case of hate speech or a possible hate speech case, people will just go directly to the law on electronic information and transaction. And it causes people to be afraid to speak. They're afraid to conduct discussion or debate. And again, that affects the democratic index of Indonesia since 2015. So again, I apologize for the very simple presentation, and I think there are a lot of kind of statements that I missed. Like perhaps I'm speaking too quickly. I'm really sorry about that, but I think that will be all from me. Thank you.
Thank you so much, Anugrah, for your concise and consolidated overview of your topic. And yeah, we will now go over to the Q&A section of this panel session. Well, luckily, we have some time left for that, so that's very good. Good. So let's start with I have a question for Kirril, and that is related to one of your key findings, which I found very interesting about the Facebook sort of approach of preventing hate speech, and that they have community standards, and that's all in place, but actually the staff wasn't so much informed about that and didn't know how to apply it and didn't even know what was in there. Can you maybe talk a little bit about that and what the causes of that? Is that because Facebook maybe doesn't care as much about it as they should, or is it rather just a matter of time before those things really find its way find its place in the culture of the company?
Yeah, thanks, Belen. Yeah, you can hear me. I take
Yes. Yeah.
Thank you. Yeah, well, what we found was a disparity between Australia and then these South Asian nations. Well, Australia's South Asian, but so there was, in Australia, there was training and there was knowledge of policy and there was knowledge of regulation. And as a result, we found that hate speech had been taken down extensively because of that. So there was a disparity between what we found in that as compared to something like the Philippines. In the Philippines, we found the greatest amount of hate speech on their website, on their Facebook sites. And we also found that as a result of that, one of the reasons for that was a lack of literacy when it came to those page administrators. Now, Facebook are, I suppose, trying to improve that. So that's helping. I can't really speak to how much effort they're putting into that. I don't really know. I mean, we've had a sort of a problematic relationship with Facebook. It makes it sound like we've had this great rapport with them, but in fact, they haven't been very transparent anyway. So we've had to, because of that, we've actually had to completely rejig the way we went about studying these comments anyway. But it seems like they are making some sort of progress towards it. But on the other hand, there seems to be what we found was there seems to be a lack of interest in certain regions, and we don't know whether that has to do because of the governance in certain countries. So under Duterte, it may be harder for Facebook to actually gain traction and make any sort of real adjustments. I don't know whether it's a cultural thing to do with other sorts of tensions that are going on in the particular area. But yeah, but overall, I think, yes, Facebook are making some modifications, but at the same time, I think there's a disparity between countries such as Australia that has this really strong governance in place that requires Facebook to do more than it does. And so Facebook have to keep up compared to a government such as the government under Duterte, where it's kind of a loose cowboy world when it comes to Facebook, and they don't need to invest as much money in it, nor they have to invest much time in it. And it kind of speaks to a sort of a tokenistic approach, and they don't, and it sort of rests there. But I'm hoping that over time that improves, and I suspect Facebook wants it to improve over time.
Okay, understood. Thank you for that answer. Then I have Robin here next to me, our executive director, who also has some questions.
Hi, thank you for the great presentations. This is Robin Remsharan from the center. I had a few questions, but one for Kirril. You've already answered one of my questions, which was going to be, do you think Facebook is really taking this seriously, or is it merely cosmetic? But you've answered that.
Yeah.
Maybe just a simple factual question. You mentioned that the number of posts regarding LGBTQ community, there is not much out there because they have taken down. Do you have an idea of how many were taken down?
That is a very good question. This speaks to what when you're talking about transparency, this speaks to our initial approach. When we first approached Facebook, our initial idea was to ask them for a cache of hate speech that they had taken from their site. So we wanted on each country their samples and what they had moderators had removed. And initially they said, yep, we can do that. And then they And then they said no. So we had to then look at Facebook. We had to go to public sites ourselves and then troll for them to see if there was any hate speech in it. So it meant that we don't know how much hate speech there has been there in the past. We don't know how much has been taken down. There was no transparency when it came to that, or that sort of cache of knowledge. All we found was that hate speech was still prevalent on posts in places like the Philippines, only because moderators hadn't known what to do and it was still there. Whereas in Australia, there's none there, not because there isn't hate speech, but just because they've got the moderators who've been educated and be able to take it down. So there was a lack of transparency. And so we don't know actually how much hate speech there was there, but we do know that there was significant amounts of it because Facebook signaled that at our initial meeting with them. And they said, yes, a lot of it, we just keep it behind closed doors. And we'll open a little bit of that door for you. But in the end, they didn't allow us to look at any of that. And
I see.
he only calls it window dressing. So.
Right, thank you.
Good.
Belen. Yeah.
Then a question for Maude. So you talked about obviously different mediation policies, techniques that you could apply, and I was wondering how culturally sensitive that is, because I can imagine that certain things will work in certain countries, certain cultures, but other things won't. How do you foresee and how do you currently see that topic?
Thanks, Belen. Yeah, absolutely. So it will depend a lot. This approach will depend a lot on a number of factors, not only cultural sensitivities, but a lot of other factors too. So one of the things that I'm also thinking about is, well, what are the criteria for this being a feasible approach in a certain place? And yeah, I mean, a mediation is always, I guess, about finding entry points and finding the right approach that is sensitive to the particular time and the particular parties. So I think that doesn't change, because this would still be a very offline process in a way. Like, it would still be about building relationships with parties and talking to them and coming to the table. So I think all of those factors around, like, well, you know, it's a slow process of building relationships and finding the entry points and finding the incentives. That applies regardless whether you're talking about mediating online space or offline space. But then there are additional things that you would need to think about around relevance of this approach. And I think one of the things that we're looking at is, well, is it a context where social media is actually driving conflict? Because if not, then this is probably not a necessary or a feasible approach. And how much is the ecosystem around conflict and around political developments reliant on social media? So how much do people rely on social media for their news, for example? There are some places where that's a lot and other places where it's much less. Is it used as a mode of expression for political views? If it's not, if it's a very restrictive social media environment where there's a lot of hardline regulation, this probably also wouldn't be the right approach. And linked to that, I think there would need to be some kind of parity between access to technology, between kind of state actors, non-state actors, and citizens. So if you have a completely imbalanced tech environment where the government has control over the technology ecosystem, then this is probably also going to be a very difficult thing to talk about, because there's just, like, you need, in order for a mediation process to work, you need some degree of parity between the sides. So those aren't necessarily cultural sensitivities, but context sensitivities that I think are important.
Thank you, Maude. So then we have a question coming in for either Anugrah or Jeremy. After the general election last year, Prabowo supporters took the street to express their discontent with the results. The government responded with internet shutdown to limit hate speech, fake news being spread. Do you
I think
do you think? Do you think this non-legal measure to hate speech sustainable or legitimate compared to the criminalization of free speech?
Maybe Anugrah.
Oh, okay. I'm really sorry. Can you repeat the last part of the question? I think I kind of lost it there. Sorry, hello?
Sure. I will repeat the last part of the question.
Okay.
Do you think these non-legal measures to hate speech problem sustainable or legitimate compared to using legal measure to criminalize free speech?
Well, I think in the terms in Indonesia right now, the legal approach towards hate speech is really, really problematic. I don't think I see, unless there is a possible this decision to amend or change the law, I don't think it will be sustainable. And instead, it will keep being used to criminalize those who actually oppose perhaps the incumbent or perhaps oppose a certain party and their opinions. So I think looking at the current condition of hate speech law in Indonesia, the fact that it's still being used, the fact that it's still being, I'm really sorry about this, and the fact that it's still using a really old law from the Dutch that was used to suppress any kind of criticism, and I don't think it will be quite sustainable. Again, I think the government really need to make a decision to really change or amend the current law, at least to make it more safer by giving certain really sorry, I forgot the term. Essentially, to give more excuses, or what in Indonesia we call it as penghapus pidana. So essentially, if you're conducting something for the interest of the people, that cannot be considered as hate speech, and that's the kind of thing that is still missing right now in Indonesia. I think that's all for me. Thank you.
Sorry, can I add up Anugrah's answer?
Sure.
All right. So, talking about internet shutdown in Indonesia, it has not only happened once or twice, but it has happened so many times. And the last one happens that in the last presidential election, the government shut down the internet because to minimize the hoax and the hate speech from the internet. So for the question, is it illegal or legitimate or not? I can say that this is not a legitimate way from the government to shut down the internet for people, because it is like shutting down the freedom of opinion rights. And according to the data from 2019, there has been an administrative law cases that stated that the government of Indonesia has conducted a crime, not a crime, I mean administrative cases against the law by shutting down the internet because it has violating the freedom of speech of Indonesian people. So I think that is all to add up for Anugrah's answer.
Okay. Thank you, Jeremy. And we actually have another question for you too. So then we would give that to maybe to Jeremy. What is the role of platform companies, companies such as Facebook and WhatsApp in Indonesia in relation to hate speech? And that is for Anugrah.
Oh, I'm really sorry. Okay, so the question was about the role of social media platforms such as Facebook and WhatsApp in hate speech cases in Indonesia. Am I correct?
Yes, that's correct. Yeah.
Okay, so currently there's not really much, like what I've said earlier in my presentation, that the government focuses on 3 approaches, one of it being the technological approach of this case by pretty much having cooperation with social media platform or stakeholders. But just like the third approach, the government is still lacking in terms of making or having any kind of programs to ensure that the social media platform stakeholders can limit the spread of hate speech. Essentially, the problem here is that the social media platforms, they don't really have any kind of strict regulation from the government. Instead, they rely on perhaps non-government organization to help them control the flow of hate speech. The government don't really have any intervention in this regards, which I think to some extent can really help the spread of hate speech even further, because then the government is not doing or implementing strict limitations or regulations toward those stakeholders. And also, to add up to my previous answers, I think the social media platforms such as Facebook, especially such as Facebook, has been the source of many political and social hate speech, if I can say that, because then there are a lot of groups, online Facebook groups, in which essentially only created to share hate speech and essentially to further relay those hate speech to other platforms. And if I may talk about something that is kind of outside hate speech, both Facebook and WhatsApp has been uh, very responsible for the spread of fake news as well, hoaxes as well in Indonesia. And again, the lack of government intervention towards these companies is, in my opinion, quite the reason behind why hate speech and fake news or hoaxes still spread a lot in Facebook and also WhatsApp, specifically Facebook, actually.
Great. Thank you so much. And then we actually have one more question for also again for Anugrah or and Jeremy. That's about, have political parties taking any positive steps to deal with hate speech in terms of policy ideas or just their best practices and actions? And maybe Jeremy can answer that.
All right. I'm sorry. Can you repeat the first question?
Yes. So it's about political parties. So have political parties taken any positive steps to deal with hate speech in terms of policy ideas or just best practices?
All right. Okay. So political parties in Indonesia, the one that becomes the legislator in Indonesia, has been trying to reform or change or even making the new act on the hate speech and even the blasphemy laws, because as Anugrah mentioned earlier about the hate speech in Indonesian law itself, it has been inherited from the Dutch in 1945 since the colonialization, and it has not been reformed or even changed a little bit. So we still use the old law, and the problem is our legislator is still fighting and is still trying to reform or change the law of the hate speech. So I think that's my answer.
So can I add up a bit to the answer from Jeremy?
Sure.
Okay, so in regards of political parties, I think, like what Jeremy said, most political parties in Indonesia, they actually support to change the current hate speech law in Indonesia. One of the reasoning was because it was an old law from the Dutch, but in the same time, political parties, they gain benefits from having the hate speech law, because there are a lot of cases, most of cases of hate speech in Indonesia was started because political parties are charging people with the information and transaction law. So actually, it's like they're doing something against the current hate speech law, but in the same time, they're actually gaining benefits as well. And if we take a look at the politics right now, there's actually a rise of a youth political party, which consists of young people. And I think the new political party in here, oh, sorry. Okay. So essentially, is it clear right now? I'm really sorry about this.
Yes, it's better.
Okay. So essentially, the current rise of youth political party, they have a more stronger stance against hate speech law, and actually they also pretty much label other political parties that still used the hate speech law as a weapon. So pretty much to show that, look at these political parties. They want to do reform, but they also gain benefits from it. They also keep using it as a weapon. So I think hopefully in the future, with the rise of new young generations, which pretty much currently being the victims of the hate speech law, can really create and push for amendments or changes to the law. That's all from me. Thank you.
Thank you so much, Anugrah, for that answer. I see we have 5 minutes left.
I have a quick question.
Yeah.
Robin here, this is a question for Maude. You mentioned that one has to perhaps look upstream and go to the source. So I'm wondering what HD's experience has been in terms of, let's keep it general, identifying the source. And what if you discover that the source is actually the government? And how has HD been addressing that? Facebook, whether it's a cause or a driver, it's been accused of aiding and abetting. And this came out in the US Congress a couple of years back. So curious to hear your experience.
Yeah, so in terms of experience, it's a relatively new, it's a new endeavor. So we haven't really taken this directly to conflict parties yet. So this is something we hope to do. At the moment, we're really thinking, well, what would it look like to have that conversation? But so, yeah, it's going to be tricky, but absolutely we're interested in this precisely because of the linkages that are often, sometimes they are very subtle and hard to find. Sometimes they're very clear. The parties themselves, whether it's a government or an armed group, are often directly utilizing social media to promote their aims or to undermine the other side or to undermine the legitimacy of negotiations. And that's precisely why we're suggesting that actually this has to be a conversation at the table, because for a long time, mediators have talked directly to governments or non-state actors around a lot of other things, governments, weapons, territories, all the other things that would fall in a traditional media conversation, but they have skirted around the issue of social media. So they haven't said, and by the way, we're also seeing a lot of content coming out from you or your followers or your supporters, and actually being able to have that conversation, I think is really necessary. So we want to talk more about that, but it's not something, I don't think anybody has really been tackling the issue of online social media usage as a tool in conflict directly at source. So this is why it's really important, but also really tricky. Not going to be popular.
Thank you, Maude. And if I may, Belen, maybe one quick question to Jeremy or also to Anugrah. So both of you referred to international conventions, and Jeremy, you referred to, I think it was General Comment 39 on the limitations, what is permissible limitations. So building on that, yesterday we had a session on Indonesia, and one of the questions which came up was, to what extent do Indonesian courts at different levels, to what extent do they consider or apply international human rights standards? And the answer was not very much, perhaps except in the case of the Constitutional Court. So, that's my first comment, which you could react to. This, and related to that, there's an old approach, maybe coming from certain parts of Southeast Asia, including Singapore, which says that, okay, I agree with international rights standards. However, I'm entitled to my local interpretation. So how would you react to that in terms of, applying the universal standards versus the limitations and so on? Maybe start with Jeremy.
Okay, thank you for the question. As I said in the yesterday session, it is correct because in our domestic court, we does not use human right or even international convention really much, just only use on the constitutional court because I think many cases we just use we conduct use positive law approach that use the remaining or the established law and regulations in Indonesia itself. So that is why the human rights itself we don't always use it on the domestic court, right? Like that. Maybe that's my response. Maybe Anugrah want to add something.
Oh yeah.
So unfortunately, I'm so sorry, Anugrah.
Okay,
We have our
okay.
next panel ready. So we would have to unfortunately end the session. But I'm thanking you all for your presentations. It was very interesting, and yeah, then we would continue with actually the next session.